So Supreme Court Justice Sotomayor recently refused to put an immediate halt on New York's controversial rifle and shotgun permit requirements. But the case has now been submitted to Justice Thomas, and Justice Thomas has sent this case to conference on Thursday, May 16th. So big developments in this case, and we need to talk about what is happening. Now, real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. First Form is an amazing company. They've been helping me along with my health journey. They have amazing supplements. I really like their mint cookie protein shakes. I drink it every single day. Their creatine, their pre-workout, all of that. Their supplements are amazing, but also they're a company that believes in freedom, American values, and they support what we do here on the channel, supporting the Second Amendment. So again, amazing company. If you want to check them out, you can use the links down below. And thank you again to First Form for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're going to be discussing a new case which is seeking immediate Supreme Court intervention. The case challenges New York's permit requirements that essentially you must have a permit to be able to purchase and possess rifles and shotguns within the city of New York. The case we're going to be talking about in this video is called Schrower versus the city of New York. Now, one of the major issues with the permit is the fact that it is purely discretionary. That means that the police department there, the city of New York, gets to determine who can legally purchase and possess these firearms. The police department gets to determine who meets the good moral character determination and essentially who does not. So they get to say who has good enough moral character to exercise their Second Amendment rights. This emergency application recently was sent to Justice Sotomayor because she is the one responsible for reviewing and approving emergency applications that come out of the Second Circuit. However, she decided to deny the emergency application and essentially kick the case. But under the Supreme Court's rules, that means that the plaintiffs here could resubmit their emergency application to any of the justices that they wanted. And recently, they submitted a new application to Justice Thomas. And Justice Thomas approved that application and then sent it to the full court for conference and consideration, and that is going to happen Thursday, May 16th. So this is a huge development in this court case that the court is going to consider this issue, so we need to talk about what is happening and what is going on in this case. The case involves a permit scheme that is in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. The plaintiffs argue that under the Bruen case, the Supreme Court struck down a similar application process that was purely discretionary. The Supreme Court found in Bruen that there was no historical support for May issue licensing permits. And now the plaintiffs in this case are arguing that similarly, there is no historical support for a purchase and possession permit like the city of New York currently has in place. In Bruen, Justice Thomas, writing for the majority, stated that New York's proper cause standard was invalid. He stated that in the decision, the court held that New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. He went on to state that the burden falls on the respondents to show that New York's proper cause requirement is consistent with the nation's historical tradition of firearms regulation. Only if respondents carry that burden can they show that the pre-existing right codified in the Second Amendment and made applicable to the states through the 14th does not protect petitioner's proposed course of conduct. So that's the backdrop of the Bruen decision, which rejected a similar proper cause standard and a similar finding of good moral character in this whole discretionary process about who gets to exercise their Second Amendment rights. Now, in this case, the plaintiffs are using the Bruen case to again attack the good moral character requirement that is included in this application process. The case was brought by the plaintiff, Joseph Schrower, who is challenging the constitutionality of New York City's discretionary licensing scheme for the purchase and possession of rifles and shotguns. On review, the district court there, the federal court, granted a permanent injunction against a provision of that licensing scheme that required individuals to prove that they were of good moral character. The judge there found that that part of the law was in fact improper and therefore issued a permanent injunction against it. That of course was a huge win, but the city of New York was not going to let that sit. And of course they appealed that up to the Second Circuit. Now, while they were seeking review of the case, they also sought a stay of that decision down below. They wanted to put a halt on that permanent injunction, and effectively that would allow them to continue this whole application process while this case was moving forward in the Second Circuit. And of course, the Second Circuit did grant that stay to the city of New York. This emergency application that was filed to the Supreme Court is essentially asking for the Supreme Court to step in on an emergency basis and remove that Second Circuit stay. Effectively, what that would do is it would allow that good moral character requirement to be removed while the Second Circuit is reviewing the appeal. The two main reasons being argued for why the Supreme Court should remove this stay is first that the plaintiffs are likely to succeed on the merits of their appeal. The plaintiffs argue that the Second Circuit's reliance on the CCIA Antonyuk case, which involves concealed carry handgun licenses, is essentially incorrect. The plaintiffs point out that the Antonyuk case is not binding on this appeal, as it involves essentially a preliminary injunction, not a permanent injunction, and it's not a decision that's a merits review. Also, Antonyuk's analysis is confined to handguns and does not involve licensing of long guns and shotguns, so it's again a different issue there. Again, the Antonyuk case deals specifically with concealed carry laws, but the Second Circuit has said that the Antonyuk's analysis is pretty much determinative on all these application processes, so they're trying to use the Antonyuk decision to pretty much stop all these other cases and all the other reviews. But the big issue also with the Antonyuk case and the Second Circuit here relying on that is the fact that the Second Circuit in Antonyuk essentially said that Bruin only applies to exceptional regulations. The Second Circuit said that under Antonyuk, that was an issue that they didn't have to review under Bruin. And here also they're trying to say we don't have to rely exclusively on Bruin because these are different cases. Bruin was an exceptional case, an exceptional regulation, and here the Antonyuk case and the Schroer case are not exceptional, so therefore Bruin does not apply. And because of that, the Second Circuit here relying on Antonyuk in the Schroer case is clearly incorrect. They're using the incorrect type of analysis, and therefore there's a critical error that must be reversed by the Supreme Court. And as I mentioned, there was an emergency application that was filed to Justice Sonia Sotomayor, who is the justice responsible for reviewing emergency filings that come out of the Second Circuit. On April 4th, Justice Sotomayor denied the emergency application that came out of this case. Now, I know a lot of people during that time were very surprised by that. Usually when there's an emergency application like this that is filed to a justice, the justice usually responsible for that application will oftentimes just simply submit it to a full court for a vote. But here, Justice Sotomayor denied the application on her own. She didn't refer it to the full court. Now, if you've been following this channel and following these cases with me for a long time, you know that that's really not out of the norm here, especially when it comes to New York. We've followed, and I stated in the last video that it's not out of the norm for Sotomayor to do that. She denied the Gazzola ammunition emergency application also on her own. She didn't refer it to a full court. Now, after that Gazzola denial, then the case was submitted to Justice Thomas on an emergency basis, and then Justice Thomas submitted it to a full court for consideration. And that's exactly what is also happening here in this case. The plaintiff submitted a new emergency application to one of the judges that they wanted. They could submit it to any of the justices. Of course, they picked the awesome Justice Thomas, who authored Bruin. They submitted the new application to him. He accepted the application and then referred it to a full court for conference and consideration on Thursday, May 16th. The May 16th conference now has a lot of 2A cases that are submitted to the court for consideration, and now the Schroer case, this issue coming out of the state of New York, is also in front of the Supreme Court. The hope is that the following week, we don't see an order list that is denying the Schroer case or any of these other 2A cases. A lot of the Illinois rifle ban cases are also submitted for the same conference dates. So hopefully we don't get a bunch of denials the following week. At the very least, we hope for a rescheduling of the conference the following week. And ultimately what that would also signal is that there is some interest in these cases by the Supreme Court and that they want additional information. Of course, an outright granting of review would be also huge and amazing, but likely this is going to be rescheduled probably a couple times. We just are hoping that it isn't outright denied, or any of these cases aren't outright denied, and ultimately we want a granting in all these cases. So that's what's happening right now in this important case. It was resubmitted to a new justice. Thomas took it, sent it to the full court for conference, and now it's going to be considered at conference. Of course, if anything else changes, if we get any more information, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars. Jets. Fighter jets.